A motion in limine is a legal request made before trial to exclude or limit certain evidence or arguments during a trial. The phrase in limine means at the threshold, and it's a way for attorneys to address potential evidentiary issues before they arise at trial. April 9th, 2025, motions 17 and 18. 17 is the state's motion for neurological and psychiatric evidence, and 18 is for the autism spectrum disorder.
The state's motion regarding neuropsychological and psychiatric evidence, as well as then closely followed by the defense's motion with respect to autism spectrum disorder.
Thank you, Your Honor. I hate to sound like a broken record, but once again, this seems to be a developing issue. The basis for our motion when we first filed it was in response to the defendant's supplemental responses on experts, the declarations of Dr. Orr and Dr. Ryan. Each of those talk about mental condition. And each of their disclosures, right on the first page, said that this evidence is not intended as mental element defenses under 18-207. So our response was, well, then it's not admissible. It's just very simple. The statute covers that. What happened after that is that it morphed now into a new position from the defendant that there are neurobiological and physical conditions that are come into play. Not to the exclusion of the mental conditions that were alleged before, but Dr. Lewin talks about the physical conditions are predominant as opposed to exclusive. So that kind of brings us to where we are for the issues for today, and I'll try to be as succinct as I can. The first issue, what was initially raised by the defense, is they expressed concern about how the defendant's demeanor is going to present to the jury as the defendant is just sitting in the courtroom at counsel table like he is right now, and assert that they should be able to offer evidence that the defendant has autism and these other disorders that make him appear, I guess, arguably like he's not involved or something in a negative fashion. The defendant cites no authority for this, and indeed, I'm not aware of any authority. We can't find any authority to say that the defense can come in and even before jury selection say, okay, ladies and gentlemen of the prospective jury, here's this expert testimony that our defendant has this developmental condition, this autism condition, and so he might appear different in court. And so please don't hold that against him. And there's just simply no basis for that, and we looked for that. It's irrelevant to any of the factual issues in this case. It's irrelevant to the elements of the offense. Frankly, all it does is confuse and try to play the sympathies of the jury, which is exactly what Rule 403 would prohibit. And we cited to the Schuler case where it talked about in the context of prosecutorial misconduct, it talked about the defendant's courtroom behavior off the witness stand is irrelevant. I think it stands for that. The defense argues that the Samuel case expands all of 18-207 to include mental conditions that don't directly relate to an element. And that's simply a misreading of the case. Samuel dealt only with subsection 4, which deals with the state's ability to request independent examinations. And the Supreme Court said that applies to any mental condition evidence the defendant opens up. It doesn't change the first sections of 207, which limit the defendant from presenting mental condition evidence. We are not planning on with that, at the risk of going into assessing credibility, so I'll touch this very quickly, Your Honor, is what we already have from defendant's experts, particularly Dr. Orr, is she talks about the developmental disorder impacts being limited to in the past, page 16 of her declaration. She said the motor problems have not impacted his functioning significantly in many years, page 19. She said she observed the defendant manipulating items effectively during her evaluation, which would be contradictory to what the defendant argues, which is not in Dr. Lewine's report. The defendant argues that he's physically incapable of committing these crimes. To whatever extent that is irrelevant, we submit on the issue of guilt. It appears to us that what Dr. Lewin has to offer largely relates to the penalty phase. Indeed, he wasn't disclosed as an expert, and we aren't going to play hardball with these deadlines, but his disclosures came out as we were moving into the disclosure for penalty phase experts, not guilt phase experts. So the state's position is twofold here. First, we'd ask that the court enter order prohibiting the defendant from offering evidence about trying to explain the defendant's demeanor in court when he's not on the witness stand. It's irrelevant, it's immaterial, it's certainly prejudicial, it's going to confuse the jury, it invites appealing to the jury's sympathies. And then the second thing is we would ask on this issue of the motor skills that the court simply reserve a decision on that until the door is opened and we have specific things that the defendant's experts might wish to rebut, whether through experts or through cross-examination. So that's the state's position, Your Honor. Thank you.
April 9th, 2025. This is motion 17 and 18 and the defense's response.
Judge, the court should consider as an offer of proof on, as it relates to this issue, the initial expert report that was provided in the fact phase of Dr. Orr and Dr. Ryan, and Dr. Lewine's report was attached to our reply for the basis of substantiating that our argument is that this is a neurological, biological disability. We are not taking the position that this is a mental condition. Clearly in the state of Idaho, one of the guiding cases regarding mental condition.
Is there an inconsistency there? Because it seems like on the one hand, you're arguing that his autism spectrum condition shouldn't be used as an aggravator, as a mental health condition. I mean, yeah, it shouldn't be used as an aggravator, as a mental health condition. On the other hand, you're arguing is not a mental health condition under 207.
So I think that it's really important. I know that you group these two arguments together. This issue that I'm talking about right now has to do with the fact phase, the guilt phase of the trial. Everything related to aggravator is at a different phase.
Are you taking the position that it's a mental health condition as it relates to aggravation and not a mental health condition as it relates to guilt phase?
I don't think we've said anything about it being a mental condition as it falls under 18207. We're talking about this being a neurological, biological disability. My understanding, just so that we're really clear about what constitutes mental condition in court on a mental health condition, is the Diaz case, which is pretty extensive about what you're talking about. That's not what we're talking about here. We're talking about a neurological disability that has to do with his brain and is a biological condition. The reason that this is important in the fact phase, there are a couple of reasons. But as we talked about with earlier about the juries judging him, the minute he is sitting in a courtroom, and the first time that a jury starts to look at him, they are going to be evaluating his physical presence. They will be judging his facial expressions, his posture, his movements, his interactions with counsel, his responses to evidence that is up on the screen, his responses to emotional testimony, and his eyes. The jury will be studying literally everything about him. We must, as his attorneys, be able to tell the jury in opening statement that he has autism spectrum disorder and that they will hear testimony that it is a neurological and physical condition or a developmental disorder. Studies show that jurors pass judgment on the physical presentation of the accused. One study in particular related to autism was in 2018 by Katie Morass, Imogene Marshall, and Chloe Sands. They did a mock jury study of 160 jurors, and half of the jurors were told about the accused's autism spectrum disorder, and the other half were not. And what the study found is that when the jurors understood what autism spectrum disorder was, they were inclined to be less judgmental regarding the physical presence of the accused. While first impressions of autistic adults are less favorable, studies like the one that I just referenced show that informing of observers of the ASD diagnosis results in significantly more favorable consideration. There are several cases for guidance to this court. State versus Spur, 921 AD 1335, a New Jersey court from 2007. The conviction was reversed and a new trial was ordered in a murder case. The court held the evidence would have educated the jury about oddities in behavior that defendant might exhibit in court or were described in the testimony of witnesses. The testimony is equally relevant to defendant's effort to have the jury understand any unusual demeanor or mannerisms he may have as a result of ASD and to explain his asserted shortcomings in perceiving and reacting to basic interpersonal cues when engaging in social interactions. He must be permitted the opportunity to present at trial evidence that tends to prove that he has a medical basis for such behaviors in order to explain himself and his condition and thereby to lessen the chance of being misunderstood by the jury. Another case out of Missouri, State versus Boyd, 2004. A Missouri case was reversed on appeal with the exclusion of expert testimony about autism. There were many similar issues as the case here, and it actually was also a stabbing case. The appellate court that the failure to allow expert testimony at trial had a prejudicial impact on the outcome of the trial. There were issues of clumsiness, awkwardness, and motor skills. Another example, State versus Suber, a 2008 Minnesota case. In an unpublished opinion, the Court of Appeals overturned a DUI conviction because the court, who conducted a bench trial, inappropriately weighed the evidence by ignoring expert testimony related to autism. Odd behavior and dexterity problems were at issue. Another case, a Ninth Circuit case, U.S. versus Cottrell, 2009, was not published in the West Federal Reporter. It's a California case. A conviction for aiding and abetting arson was overturned because the court excluded expert testimony related to autism on the issue of specific intent. The court held it was an abuse of discretion to exclude the evidence. There's also a brand new law review article out of the University of Alabama, March 4th, 2025, by Jenna Hayes, published, called Autism, Culpability, and Sentencing. It was just recently presented at the American Psychological Law Society conference, and it addresses many issues related to autism spectrum disorder in the criminal justice system with strong recommendations that expert testimony at trial is critical. The jury needs to know from the very outset that they will hear testimony about Mr. Koberger's autism spectrum disorder generally, and how his physical presentation in the courtroom should be considered. For example, aside from his flat affect, piercing stare, stiffness, holding still, when emotional evidence or picture evidence comes in that a neurotypical person will react to, he will not react. And that is only because he has a physical disability that prevents a neurotypical reaction. It would be unfair for him to be judged for that given his disability, or at the very least, the jury needs to have some understanding of why that may be. As for issues that relate to state of mind, at the very least, the jury needs to have some understanding of why that may be. As for issues that relate to state of mind, it does depend on what the state offers. We agree with the state on that aspect. If they stay away from the issues regarding cleanliness and a missing shower curtain and speed in which the crime occurred, and wearing gloves or showing him at various places wearing gloves with some sort of negative attribute that he is doing that to hide DNA as opposed to what's going on with his autism, it's our position that that opens up the door to the opinions that the experts have expressed. As it relates to...
I didn't understand the reference to speed at which the crime occurred.
Oh, well, there's the state, there's a disclosure by the state of one of their detectives.
I understand the detective's statements, and you have in the report a reference that he has a historic fine motor skill issue, and you have no expert testimony that he would have been incapable of doing this.
Well, I don't know that we would seek to offer an opinion that took it that far into the jury province about no capability to do this, but in terms of his fine motor dexterity issues.
All disclosed is a historic issue with some fine motor disabilities, like not being great at tying his shoes.
Well, I disagree that that's all that the expert said. The expert indicates he has problems with dyspraxia and went into great detail about the issues, that what she saw with fine motor dexterity as it presents to this day. He did absolutely have those issues as a child, and there are still things that are present in him. And you know, to the extent that that's an issue, the best person to explain that to you is not me, but perhaps a more of an offer of proof beyond this, outside of the presence of the jury. So what you would know, the testimony would be that we would offer on that issue, or giving us direction to specifically go get information about that issue that we might try to elicit. But I don't want my representation to you as a non-expert, as a lawyer making this argument. I'm not qualified to tell you what's going on with his exact dexterity issues. He has fine motor skill issues. He presents odd physically, and it is a different presentation with what he's got than someone who might be sitting in a courtroom, perhaps with missing a hand, for example. Another significant issue that is impacted by his ASD is his decision and ability to testify. The Burr case is instructive because part of the basis for the reversal was that Mr. Burr was encouraged not to testify out of fear of how his autism would come across to the jury. Because of his ASD, because of Mr. Koberger's ASD, decision-making is already very difficult for him. If we cannot let the jury know about Mr. Koberger's autism, the decision about his testifying will be nearly impossible for him and for us as we guide him. We need to avoid misperceptions of the jurors, and the only way to do that is to inform them. The cases I have referenced discuss how the constitutional right to due process is violated when a jury does not get to take into consideration this specific type of evidence. There's one other way that I want you to think about this, one other frame of mind. Imagine if you do not let this testimony in phase 1 of the trial, and the jury convicts Mr. Koberger. How angry and misled might those jurors feel when they learn in mitigation, where without a doubt this comes in at mitigation, that he has this disorder and it has them second guessing themselves. We must avoid that possibility. We ask for an order to allow its admission. We are not asking for carte blanche ability to lay all of that out in opening statement. This is something where we have no problem, where we take a step-by-step approach, but we've got to be able to tell the jury in opening statement that he has ASD. Thank you.
April 9th, 2025, motion 17 and 18, and the state's rebuttal.
So what we've just heard from the defendant still begs the question of what's relevant and irrelevant in Idaho. And I think the case law is clear to the extent there is case law that the defendant's appearance when he's not on the stand is not relevant. I think that the court, if it has concerns about that, could add language to the ICG 202 that talks about the type of evidence the jury can consider, to say the jury may not consider the defendant's demeanor as he is seated in the courtroom, if the court feels that's appropriate. I'm not sure it's necessary because 202 specifically lists what jurors can consider, and the defendant's demeanor is not part of that. In response to Your Honor's question about, or observation that there's no evidence from an expert here that the defendant is incapable of committing these crimes, the response from the defendant was, well, yeah, that's right, which is exactly our concern, because the defendant in his filings took what little was in the expert disclosures and then stretched it out to this conclusion that the defendant is incapable of committing the crimes when the experts don't say that. I mean, they are essentially creating an opinion that doesn't exist. So, Your Honor, our request stands. Certainly the evidence that's being proffered about his demeanor is not relevant. It shouldn't be admitted. And if there's an issue that comes up about the defendant on the stand and his appearance there, I think we can address that as it comes up. Likewise, if the state opens the door to questions about the defendant's behaviors, which we are not intending to do, we can address the issue at that time. So we'd ask the court to defer any kind of ruling on those hypothetical situations. Thank you, sir.
April 9th, 2025, motion 17 and 18, and the defense is getting up for a secondary rebuttal.
You know, if we didn't have 2.5 years of media coverage to know how Mr. Koberger's physical presence has been perceived, the state might have a little bit more credibility with that argument that it's not relevant. But we have extensive media coverage that refers to him as evil, as an incel, as looking like a monster with very dark eyes, and it's all based on their analysis of him sitting in the courtroom. Pardon?
None of that is his autism spectrum, what you just mentioned.
But his physical presence is what the media has been judging, which is the same thing that a jury is going to do. So my point is that for the state to say that it's not relevant, we actually have in this situation the ability to point you to the fact that that is not true. because what the media has done, I mean, there are, even before the cameras were cut out of the courtroom, there were all kinds of zooming in and stories with experts doing body language studying about him, including the fact that this is how he holds his hands, and there's details about that. So it's disingenuous to say that he's not going to be judged by his appearance. That is exactly what jurors are doing. They're judging the evidence. They're staring at the accused. They're looking for an accused to be remorseful and emotional at evidence that makes everybody else feel bad, and he is not capable of doing that through no fault of his own. And there is, I just explained to you that there are studies that have been done and there's case law on this, that it's important that the jury be informed.
There's also a case law that says that none of what happens except in the testimony is relevant. So how do I square those two things?
Because
Or I give the jury an instruction that specifically says, don't judge this case based on anything except that you hear on that witness stand. And then if I do this, what you're asking me to do, I'm basically telling them, but that's okay.
well, the state's asking you to give a jury instruction that says that. We're asking you to let us put
Part of the standard
testimony on.
instruction is that the jury may not consider as evidence anything other than the testimony and exhibits admitted in the trial.
Judge, I just quoted cases to you where we don't get to live in a state of denial, right? We can pretend, but that's not what exists in society.
I
So
have to
we
live
don't get to live in a state of
what the law
denial.
is my concern.
Pardon?
I have to live in a state with what the current state of the law is
And
in
I just,
Idaho.
well, I just gave you
You
examples.
gave me no Idaho cases.
But Judge, you can have the courage to be the first one to set it right here then, because autism spectrum disorder is very real in our society. 1 in 59 people have it, 4 times more common in males.
I'm not in any way trying to downplay those that may be diagnosed on the spectrum. I'm trying to figure out how do I do this where I have settled legal precedent that I'm supposed to follow that says the jury may not consider as evidence anything other than the testimony at the witness stand. They can't consider, they're not supposed to consider the demeanor of the witness. Now, I will say, having seen Mr. Kohlberger over numerous days now, I haven't seen anything unusual in terms of his demeanor. But, I'm not, scrutinizing him on YouTube the way maybe others are. But I understand your concern, and I'm not trying to downplay it. I'm just trying to understand how I get there in light of the legal requirements that I'm supposed to tell the jury, don't consider any of that. Maybe the way is to say, the way the parties appear, what happens at counsel table is not evidence. You shouldn't be concerned about it, and it should play no role in your decision. Would that do it?
Judge, the proper way to do this is through testimony. I just went through a litany of cases where that's what the courts have said in other states is the way to handle it.
I don't think those cases were those cited to it?
They're not Idaho cases, no. But then it's an issue of first impression here, right? And so you get to make the decision, and you can get it right. You can allow the testimony, right? I mean, if it's an issue of first impression and you're looking for guidance around the United States, then do what other states are doing. That's the solution, not a jury instruction.
I'll take the matter under advisement. The counsel cited cases that weren't cited in the briefing, so I'll need to look at those.
April 9th, 2025, motion 19. This is the final motion regarding the defense and striking the death penalty. First with the ASD.
All right, let's talk about the motions to strike the death penalty regarding the same issue.
All right. Focusing now to a different phase of the trial and why this should be a grounds to not even let Mr. Kohberger be considered for death. There's too great a risk that constitutionally protected mitigation can be reliably assessed by a jury. The impairments cited by the United States Supreme Court in holding that the death penalty is unconstitutionally reliable for juveniles and people with intellectual disability apply with equal force to people with ASD, and specifically to Mr. Kohberger given his deficits. Courts are expected to apply general legal principles from Supreme Court precedent to new facts. The United States Supreme Court just reiterated this in Andrew versus White, a 2025 decision decided January 21st, 2025. The general legal principle here is that the Eighth Amendment and its requirement of heightened reliability in capital sentencing applies. Unreliability exists when a defendant has an inability to present mitigation evidence, which creates an unacceptable risk of wrongful execution. The four impairments in Atkins which apply here are A, less able to give meaningful assistance to their counsel, B, demeanor may create an unwarranted impression of lack of remorse for their crimes, C, typically poor witnesses, and D, mitigating evidence of ID can, quote, be a two-edged sword that may enhance the likelihood that the aggravating factor of future dangerousness will be found by the jury. All four of these impairments apply to ASD generally and to Mr. Kohberger in particular. As to less ability to give meaningful assistance, extremely rigid thinking, he perseverates on specific topics, processes information on a piecemeal basis, struggles to plan ahead, and demonstrates little insight into his own behavior and emotions. He may understand the definition of mitigation, but he has no ability to assist us and understand if what might be mitigating and why. The impairments that he has go all the way back to his very young years, where he walked on his tippy toes, rocked on all fours for extended periods of time, could not engage in imaginative play, wrote his fives upside down and backward. He was provided with extensive supports in school. He was evaluated for ASD, but not properly diagnosed, and bring that to current time where he is at age 28, where he has few personal relationships. He does not have any insight into things like the fact that he once volunteered at the Special Olympics is mitigating, or that he helped save someone's life on the job, and that's mitigating. He can see the logic in the word mitigation, but he has no ability to understand and help us develop a case for him for mercy. His demeanor, he has a limited range of facial expression, odd eye contact, and intense gaze with subtle rocking, sitting very still. This is important because of the impact that jurors assigned and give tremendous weight to perceived remorse or the lack thereof. So again, I'm talking about not phase one, but if we get to phase two, this perceived remorse and their decision about the death penalty. As evidenced, as I've explained, by the media demonizing his appearance. As a poor witness, he has difficult picking up on nonverbal cues. Tone and cadence are abnormal. Affect is stiff and language is disorganized, repetitive, and oddly formal. He really struggles with making decisions, such as, like I expressed, the decision to testify. He needs instructions repeated to him. He's easily distracted on what is happening around him, or so focused that he's lost in the big picture. He perseverates on unimportant details, and these are symptoms of his disability that will either unfairly keep him from testifying on his own behalf or alienate him from a jury and make him easily trapped on cross-examination. And the double-edged sword applies as well, because the stoic affect and incongruent facial expressions may be seen as a lack of remorse, an inability to react to emotional moments that call for emotion, which is often an aggravating factor for juries. Studies in our motion related to striking the death on page 22 to 23 cited the bias towards people with ASD. Again, the media coverage has repeatedly described him as soulless and evil. I want to address the issue of national consensus because the state pointed that out. First of all, the national consensus standard is not something that is required if you make an unreliability finding. But even if you determine that a national consensus is required, there is one because of the factors analyzed, in Atkins all apply to ASD as the class of person that society wants to protect. They are the same vulnerabilities. ASD individuals like Mr. Kohlberger are labeled protected handicap students, below basic academically, unique thinking and reasoning make intellectual function difficult to summarize, poor fine motor skills, not comfortable speaking or overly verbose, can't make eye contact, require repeated instructions. Those were all specific statements in his school records. The Supreme Court has not established a clear...
Doctoral program?
Pardon?
Was that before his doctoral program, in terms of his academics?
Yeah, the school records that I'm reporting here were definitely for him as a small child, but I wouldn't say that that there weren't issues that were derived as when he was in undergraduate or his master's degree program. And the other thing that's important is that it's really inappropriate, based on what the experts say, to put more weight on someone's IQ and less weight and make that IQ overcome adaptive function issues. The Supreme Court has not established a clear methodology for determining when a national consensus exists. The court has looked at state legislators, but also medical and psychological research, international standards, and there is an rapidly increasing awareness of ASD across society, including in the legal system, as outlined in our briefing. As a society, there is a consensus to protect this class of persons. And if you don't agree that any of those arguments are convincing, then some court needs to have the courage to be the first to declare a consensus, and that should be you. Thank you.
April 9th, 2025, Motion 19. This is the state's response to striking the death penalty for ASD.
Your Honor, I want to start with the Atkins decision because the U.S. Supreme Court are the experts that this court is bound by, and that court specifically found in Atkins that there were two reasons why the individuals they were contemplating could not be subject to death, and it was sub-average intellectual functioning plus significant limitation in adaptive skills. What the defense is asking is to eliminate that first critical component and look only at adaptive skills. And the defendant's not the first to try that. in Idaho, the Idaho Supreme Court has rejected that argument in Dunlap. Now, it wasn't about ASD, but the argument was the same, that mental illness has some of the same conditions that were talked about in Atkins, and therefore the Eighth Amendment prohibits execution. I would note that the Idaho Supreme Court did not even entertain that argument sufficiently to do a symptom by symptom comparison between the mentally ill and those who were found to be intellectually disabled in Atkins. Instead, the court cited, by my count, 10 other courts that had rejected similar arguments and said, we agree with them. I don't know how you can read Dunlap in any other way than the Idaho Supreme Court has said it does not violate the Eighth Amendment unless and until the US Supreme Court extends it. And they haven't done that, and they still haven't done that. Now, on the national consensus issue, national consensus is a critical part of an evolving standards of decency claim. It's at the very heart of that claim. That's what it means. An evolving standard of decency requires some kind of national consensus. And the critical place you look for that are the actions of state legislatures. Not a single state has said that someone with ASD cannot be executed. They cited to 2 states in their brief to support their claim. Neither of them have laws that preclude this. In fact, their laws, both passed within the last 5 years, did add to the list certain mental illnesses, but they did not add ASD. That means those legislatures considered which mental illnesses should we add to this list and rejected the idea of adding ASD. So that's not the national consensus that the defendant would need for this type of claim. Based on Dunlap and the plain language of Atkins and the complete lack of any kind of national consensus, we would ask this court to deny the motion. Thank you.
April 9th, 2025, motion 19, defense's rebuttal on striking the death penalty for ASD.
I addressed the issue of national consensus initially, so I'm not going to repeat why that is something that you don't need to find. But I do want to point you to another resource that is really informative, because what we're asking is that you make this finding on the unreliability principle. And Scott Sunby has an article titled "The True Legacy of Atkins and Roper, the Unreliable Principle and the Unraveling of the Death Penalty." And that explains the court's pathway on how Atkins and Roper is focused really on why society protects people with vulnerabilities, and why people with vulnerabilities like ASD cannot properly be reliably mitigated in front of a capital qualified jury. And that's why you should strike the death penalty in this case. Thank you.
Thank you. I'll take the matter under.
April 9th, 2025, motion 19, part 2 of the defense's motion for striking the death penalty regarding discovery.
Which is the motion to strike the death penalty regarding discovery.
Your Honor, we are asking the court to strike the death penalty as well as issue some additional rulings in this case as it relates to the discovery issues. Your Honor, we're asking the court to look at this not as a Brady violation, but as a due process violation. And it's important to understand a little bit more about the discovery to do that. First, I'll start with defense counsel's obligation. In any case, defense counsel has the obligation to meet its constitutional requirements of effective assistance of counsel, and that means that we have a duty to investigate any of the state's claims and review the state's discovery. There's a heightened sense of that responsibility in a capital case. Death is different. That's been said time and time again throughout the United States and state courts as well. So we need to be able to review all of the discovery. We need to meet that obligation, and we cannot. 68 terabytes in our briefing. I won't repeat it all here, but
I don't have a clue of what's in there in some senses, because I don't know how much of that is music? How much of that is video and movies off personal devices? How much of that is things that no reason to look at?
Well, the problem is, Your Honor, there is a reason to look at it. There are tons and tons.
Why didn't you bring a motion earlier asking for intervention to have me do other things and rather waiting to tie it to the death penalty at the end?
I'd say that's a bit of a mischaracterization of what's happened.
The first time we met, you told me about having received the state's discovery and the number of terabytes. And the first question I asked you was, have you looked at it? And you said no. You hadn't yet looked at it. And we talked about the trial date, and I moved the trial date back a little bit for that. And I haven't heard a word since then that you haven't had enough opportunity to review the discovery or to do the discovery.
Well, I'm here to tell you now that we haven't reviewed all of the discovery. Over the course of the case, there have been multiple emails and letters back and forth with counsel about discovery. We've had motions to compel discovery. When I first met you, I was very candid with you about the size of discovery and that our team had not looked at it all. Since that time, we've continued to receive additional discovery. And probably most importantly, that brings us to now, why now? I think that's a fair question. Since we began with the expert disclosures, and I'm not going to go all the way back through that, I talked about that exhaustively, but that was a real turning point for us, that when you're moving along with a schedule and a pace, in this case, especially with the sizable amount of discovery, and I want to tell you what's in there in just a second too, but we're moving along at a specific pace, and the expert disclosures, we've talked a lot about that, and those were not adequate. The court told the state to do a better job. We've talked exhaustively about that, but that disrupts the flow of everything that we're doing when that happens. We had worked diligently to get motions filed and to get our other motions that were being heard in January prepared and to meet our expert disclosure. And now in the time since January 24th, we've had repeated meetings with experts with new information here to find out what it means, new information there to find out what it means. And it just hasn't allowed for enough time to focus on the discovery. And that's not all. We have these motions in limine. We've talked quite a bit about the dollhouse and the issues with the dollhouse. That takes time. Everything like that takes chunks of our time. We don't have all the discovery reviewed. That discovery consists of thousands and thousands and thousands of pages of police reports. I know the court has a little bit of a glimpse of that. The court asked the state to give them Detective Mowry's police reports that he authored. I think it took him 10 days to get them all gathered up to the court. That's one officer. That's just one officer. We have, I think, over 15,000 photographs.
4 years in the fall,
No,
the homicide?
no. It's 3 years in the fall since the homicide. Mr. Koberger was arrested.
Fall of 26 is what I was referring to. So 3.5 years.
The homicides happened in 2022, November. So we are 2.5 years since that happened. We're in 2025. Would be 3 years in November of 2025.
Happened in November of 2022. Oh, you're right. Never mind.
It's been a long day, Your Honor.
It's been a long day. I'm off by a year, and I feel a lot older than that, than having aged more than just a year in this hearing. But regardless, at what point are you ready? Does that mean that in no case where there's a lot of data, can we have the death penalty?
Your Honor, that
Took on a new death penalty case since you came onto this case. Why would you do that if you were not having enough time on this case?
Well, Your Honor, when I agreed to take that case, we had a certain pace going in this case already, and then things have happened since that point in time in this case that have set us back.
the skeptic would look at this and say, well, this is what Judge Boyce did when there was a last-minute discovery issue. This isn't a last-minute discovery issue. And it seems like this could be viewed as being calculated to try to be a method to get the death penalty off the table by waiting until the end to bring to the court's attention the contention that you can't get through all the discovery.
I'd ask you to look at the things that have happened since I would say our status conference, the first time we met, when I was hopeful that we could get through a number of the things that we still had left to do. There are things that have occurred that have taken an extraordinary amount of time. There are a lot of things that we haven't had a chance to look at yet. We continue to go through discovery as rapidly as we can. We're just not going to get through all of it by the time we get to trial. Part of that is the way that it's organized, and that's why part of our request is to have the state give us the documents they rely on. And
With giving hot documents is if they don't point out a document that you later say, oh, we should have known about that one. Now somehow they're culpable for not seeing the document the same way you did. And so that's why courts are very hesitant to employ that remedy, because it makes the state kind of do your job for you.
Your Honor, I would let the court know how we've received discovery in this case. And this has been a topic between counsel since the initiation of the case. The discovery goes to the police department, and then sometime later, the state gets it, and then they get it to us. So there's a delay already, but the documents don't come in any organized fashion. When you received all of Detective Mowry's police reports, those would have been scattered over probably a year for us to get. We litigated the video, 1112 King video. We litigated that for about a year before we got the full copy of that. Those are all things that take time, and we are now months before trial with the cumulative effect of what's happened. And we now are faced with the issues with expert disclosures. Hearing the state today, I don't expect they're done trickling in expert disclosure after expert disclosure. At what point is it enough when we can be counting on that's it, we can get ready? The court's discovery deadline came and went. A lot of additional discovery has come past that deadline. At what point is that enough? I'm picking up more discovery today if I can meet up with the prosecutor.
Is it a penalty-based discovery?
I don't know. I haven't seen it yet.
Part of my problem is I don't know, because you're very vague about what it is you haven't been able to do.
Well, let me tell you then. There is surveillance video from all of the university, all of U of I, and there's probably some pretty critical places where that discovery or where that video exists. I haven't watched that. I've sat down to watch it on several different occasions, and other team members have sat down to watch parts of it too, to try to see what's there. The way we've received it, it's not labeled in any fashion at all. I can open up a folder and I can look at something and figure out what date and time that's from. And there's multiple cameras and multiple days. There's no index, there's no guide to what it is. So I haven't looked at all of that. There's a couple of additional video footages that I haven't looked at. Now, if we want to start talking about cell phone data and third-party digital data, I have an expert who said it would take 3 years for him, an expert who knows how to do this, to go through every single piece of that. Now, he's been through a lot because we've had a little bit over 2 years to work on that. Not a full 2 years because we haven't had that discovery for the full 2 years. But there's quite a bit that I haven't looked at. I don't have an expert giving me even a report. We're not completed with that. I think I've read most of the police reports in this case, but I haven't read the thousands and thousands and thousands of tips that came in on this case. Don't think they're all not relevant, though. Recently, we came across a tip, just in trying to work through some of these issues, we came across a tip that would appear to be an alternate suspect, and we're trying to work through that as rapidly as we can. It was quite a surprise to come up with that. There's got to be more in there that I need to know. We were disclosed a bunch of email communication between different law enforcement officers, different lab personnel. I probably have read about half of those by now, and different parts of our team have read different parts of it, but we don't have it completed yet. Those are some quick examples that I can give you. I've looked at every picture, and I believe I've read every police report. There's a lot left to do that could have things that are favorable to Mr. Koberger. In January, I had to stop doing that because I had to start worrying about the expert disclosures that we didn't get. I continued that through February. We've responded to the motions in limine. We've responded to the dollhouse. We've met our deadline with our mitigation experts. We're meeting the deadlines that are set out, but there's only 24 hours in a day. This is what's happened here is not satisfactory. That the discovery is not in an organized fashion. It's not in a searchable fashion. We've encountered documents that have been locked, most critically the entire DeSales record for Mr. Koberger's education at the DeSales University. Those were locked documents. They were a complete mess. It took one of our team members probably 10 days to get them in an organized fashion where we could understand what document went with what other type of classroom or assignment or other event. I will tell you about the motion in limine we didn't discuss today, the self-authenticating records. When we received the state's initial list, these are the list of things that we want to put in with a certificate. We went through those discovery folders, and those didn't contain just one document. They didn't even contain a document that made sense about what the state was trying to do. That took me personally about 10 hours to go through all of those folders of discovery so that I could write a response to that. The state replied abandoning wanting to use about half of those right out of the gate after I'd spent the 10 hours. And we come today prepared that the court was 100% right. Those pleadings weren't ready. There's not a packet with a certificate of authenticity for the court to make a decision on. The court was right. But that doesn't mean that I can't be prepared. Those things take time. And when we're talking about the amount of discovery that's left outstanding, everything that happens like that eats up those minutes. In this situation, Your Honor, it's not that we saw what Judge Boyce did in Vallow and thought this is a great idea. We are at the end of our rope doing everything we can, and I know about what Judge Boyce did, and I have to come to you and say, you need to do this too. This impacts Mr. Koberger. I can't not bring this motion because somebody might think I was waiting to the last minute. I can tell you we weren't. We weren't. We've been working as diligently as we possibly can work on this case. We have understood the court's...
Have you gone to Judge Monson to ask for additional resources?
Well, Your Honor, we do have an additional resource. We recently added our attorney, Ms. Barlow, to...
A team of another 5 or 6 paralegals, for example, to go through stuff.
I can definitely do that. I don't know how that puts the information in my head fast enough, but I can definitely do that.
Of having litigated many very large cases, you have staff that tell you, here's an important document. And then that one comes to your attention from the, as you pointed out, the gigabyte or terabytes of probably pointless video cameras that nobody's ever going to rely on, that don't show a thing.
If I'd had a team of 5 more paralegals that understood the case already, that would be one thing. I certainly can ask Judge Monson for additional resources. I certainly can try to get somebody to understand what the issues are. I don't have a problem doing that, but that doesn't change where we are now. That doesn't change the things that have come up that have impacted our ability to prepare. I understand that the court has said this is the trial date, it's carved in stone, and I've done my best to adhere to it, and I'm here now saying that the death penalty needs to be struck so that there's fairness to Mr. Koberger. The remedies for the court are to strike the death penalty and to have the state give us a list of Brady documents and the documents that they want to rely on. This is a huge amount of discovery, and we don't have the same resources of the state.
I'm going to get a list of the documents here in terms of exhibits in the next few days, I would imagine. I'm not sure. April what is that date?
Well, it's just a little over a week away. Ours are due the same day.
Well, but if there's things on there that you didn't anticipate, This is a process where there's the ability to add things by your part if there's things that you didn't add, if you discover something else in there. But the point is, you will know generally the universe of documents that the state's going to rely on in 2 weeks.
I will know those. I will know those. And when I produce mine, the state will know what I can rely on, but I don't know what I don't know yet.
It sounds like you would never know what you don't know, given what you've told me it's going to take, 18 billion years to get through.
Well, I don't think it'll take 18 billion years, Your Honor. I think that,
Well, it was several decades, as I recall, is what you'd said, or several hundred years.
I can promise you I won't take several hundred years, but
You see my point? That's what you said it would take to get through that, an individual. I have a hard time taking that at face value because that's not a realistic answer.
my realistic answer, Your Honor, is that we were working, and we still are working diligently, but the discovery was one of the biggest things that we were doing methodically, going through that discovery so that we could understand everything that the state had given us, even in its disorganized fashion. And that changed with the things that have come up over the last few months. Our entire plan, our schedule has changed to be responsive to everything else. And that's not Mr. Koberger's fault.
Or complex litigation generally, when you're in the expert phase. I mean, that's not unusual.
I guess, Your Honor, I think it's unusual when deadlines are blown by the state or not adhered to by the state, and our client pays the price for that. So I do think it's unusual. I think it's unusual to receive discovery where you might get 23 pages of a transcript, and then 4 weeks later, you get the rest of that transcript. We have had to match up discovery every step of the way. I don't think that's usual. I think there are things that have occurred in the path of discovery that are not usual at all, and I think things that have happened.
I guess my point is if the discovery is being provided in that way, this is something I should have heard about in September.
I advised the court that we were not
That you had not yet gotten through things,
I-
but you didn't advise the pattern of the way you're getting discovery in terms of, incomplete here and incomplete there, et cetera. That's all new.
I agree that that's new to Your Honor. I know that we discussed a sizable amount of recent discovery we had gotten. Those issues came up prior to this court taking the case over. We had talked about the way discovery was being received early on in the case. We filed discovery request after discovery request in addition to talking about the mismatched way discovery was received. That has been put on the record. My hope was with the state's discovery deadline, with that cutoff date, that we'd be able to pull it together. My hope has been that until these new things have happened to shift us off the course that we were on. And I'm here to tell you about it today. I think it would be a lot worse if I stood up at jury trial and you said, "Is the defense ready?" And I said, "No, we haven't read all the discovery." So this is my opportunity.
Right, that would make me happy.
Well, this is my opportunity to let you know. We filed this motion several weeks ago, so the prosecutor and the court's been advised. We have been diligently trying to get through it all. We can't. It wouldn't matter if I had 10 more people right now, given the shortness of time with that. But I know that there are remedies the court can take. I understand I'm going to get their exhibit list. The court can order them to tell us what are the hot documents, where are the Brady issues. It's not enough just to give it to us in this volume of discovery. We need it identified, especially given the short time. But our position is that the court should strike the death penalty in this case. It will take the heightened level of pressure down, and it will allow us to focus on the trial phase only rather than the mitigation phase as well. There is precedent in Idaho. The court knows.
Circumstances were completely different, though, counsel.
I'm not saying our circumstances are identical, but it's a due process issue, just like was analyzed in the Vallow case. That was analyzed as a due process issue because counsel didn't have the opportunity to be prepared. And that was grounded in other case law. That was Riviera versus Clemente, Grover versus Florida, and Lopez versus Matthews. And those apply now. We do not have an opportunity to meet the state's discovery, even though we've diligently been trying to do so. And this is the appropriate remedy. And we're asking the court to make the orders for the state's disclosures and to strike death.
April 9th, 2025, Motion 19, Part 2, State's response to striking the death penalty for discovery.
Judge, in this case, the state has made every attempt to try to comply with Rule 16. 7 days after defense counsel entered her notice of appearance, she indicated she wanted everything that we had. And we started the discovery process. This was continued routinely throughout this case. Generally, documents such as police reports, lab reports, et cetera, were bait stamped and then turned over, and essentially turned over in the same way that we received them, in the same order. As they were done and turned over by various investigating officers or whoever, we put a bait stamp on them. Photographs were done in the same fashion. Larger files, and I could say that, for example, most of the files that come from the FBI tend to be larger files that can contain a multitude of different things. Those were placed in an AV folder and discovered.
Next. Were they meaningfully indexed?
I can tell you for FBI documents, the defense was provided essentially an index for all FBI documents because they requested everything that was on a shared drive for the FBI, and that was turned over with a searchable index.
Mention of a problem because of the password protection of documents.
Yes, and we addressed that. Actually, we first heard of that in, I believe, April of 2023, and Mr. Thompson wrote a letter to Ms. Taylor saying that he understood that some of the PDFs were locked, but advised counsel they could get around password protection by hitting print to PDF and then saving, and that allowed those documents to be searchable. They were advised of this over 2 years ago. It's true there's a large amount of discovery. There was a 6-week-long investigation prior to a substantiated tip that led to Mr. Koberger's arrest. So yes, there was a massive amount of discovery. We extracted cell phones for anyone that had any kind of connection to the victims. We gathered surveillance video for weeks, if not months, of random places throughout Moscow trying to figure out what happened. So to answer your question, there's a ton of discovery, and the majority of it is completely irrelevant.
Are you aware of any Brady information that is in the the cameras that are not the ones listed in your route of travel? And
No, Your Honor, I am not aware of any Brady material, any exculpatory material that's within those videos. The defense is right. All discovery was routed through MPD. We have a central location for collecting all the evidence, all the information, and then it was sent to our office. And then it was primarily reviewed by myself and Mr. Thompson, given approval, and then immediately sent over to defense. Files were kept in the same way by our office as we've discovered. That's how they've been maintained. And the parties are just on equal footing in this regard. Defendant's motion is just replete with these mischaracterizations and just completely false assumptions. For example, they say that there's so many investigators involved on this case. While that might be true that there were many investigators involved on the investigation, those investigators don't help us in the administrative task of organizing and sending out discovery. Further, we do have a PBK case management system, but it is not at all the way that it is described in the defendant's motion. For example, we don't have this global search function. We don't have the ability to just generate reports based off of witnesses. Agencies can't just directly upload into our system. We just don't have that capability. The reality is we rely on a self-created spreadsheet. Throughout the case, defendant has filed over 20 separate requests for discovery. There's been 400 itemized requests for different items, and the state hasn't just simply responded with whether or not we complied. We directed them specifically to where they could find that specific item, if it existed, the location, the description, and the date that it was discovered. I would just go back to that massive dump that we were talking about of the 50 terabytes of data. Defense has had that for over 2 years. It's hard to, I guess, rebut a lot of the allegations because there's no specifics. They just talk in these general terms about all of this data, and I'm not totally sure how to respond other than we've given over the data as we've received it. And they've had the majority of it for several years. Most importantly, defendant has not specifically pointed to any particular piece of evidence that has been withheld or any actual prejudice suffered, and instead just points to the vast amount of discovery, which we have absolutely no control over. The state has in good faith complied with our discovery obligations, and there's just simply no basis for a sanction. And so we had asked this court deny their motion. Thank you.
April 9th, 2025, Motion 19, Part 2, Defense's response to striking the death penalty for discovery.
This motion is not about withheld discovery. This motion is about discovery in the format it's in, the vast amount of it, and what's happened over the last few months that have taken us off track and our inability to be prepared. And that remains true. The 50 terabyte server that we received sometime in April of 2023 is the one that contains the U of I footage, and it contains a lot of footage around the town. We have been able to go through most of the footage other than the U of I. When the court asked to prosecute...
Counsel, is there any known Brady material in the U of I surveillance cameras?
Not to the state's knowledge.
Your Honor, I think you'd have to watch that at various relevant times to know if there is or not. I think when you're thinking about Brady material, when we're thinking about video surveillance, and we'll go back to what we talked about the vehicle before and how Special Agent Immel's going to testify, there very likely are vehicles, light and color, white or silver, on all kinds of different cameras. Those could be Brady depending on what he has to say, but they should certainly be looked at. We're trying to look at that as quickly as we can to understand that. We've watched a lot of the video that's contained on that server. Also on that server are vast amounts of bank records, vast amounts of cell phone for all of the people that Ms. Jennings mentioned, the deceased and people close to them and other people.
They've indicated that their experts have examined that and found no connection between Mr. Koberger and the decedents.
I'm grateful to have recently learned that. I mean, that's what we believed But that was in that March disclosure when they said that they'd examined those, and those were computers, the 7 computers, I believe. It's that kind of thing that takes a lot of time. In addition to that server, there's all of the other information that comes in different ways. I'll give you an example of the delay. We received a lab report that was dated March 30th. The state received it March 30th, and this wasn't this year. This was obviously not this year. It wasn't even last year. We didn't receive it until May 8th. So the delay going from Moscow Police Department getting it, the prosecutor getting it, to getting it into our hands, that's well over a month. That's a long time for delay for the routing process. I think it's important to realize that the FBI index we have, you can't push a link and get to the document, but I do at least have that index. When we're talking about locked documents, the print to PDF, that's the problem. That's the steps, the additional steps that it takes when we're talking about thousands upon thousands of pages of documents. I think it's hard to imagine that there's not material somewhere in there that isn't favorable to the defense in some way. We recently found that, and we found a pretty good lead that we're trying to follow up on. And that is really what it comes down to. This is not organized data. It's not easy to go through. We've made substantial steps. The due process requires that something be done, and striking the death penalty is the thing that must be done.
All right, well, I will take with respect to the witness, with the exhibit list. Now, I will say the exhibit lists need to be specific and detailed, not Exhibit 3 video, not Exhibit 3 video from X Bank. It's Exhibit 3 video from X Bank, minutes 25 through 27. Detailed, specific. I would also look at as a issue whether it might be appropriate to require the state to certify that it is unaware of any exculpatory material that it views as exculpatory, that it would, for example, feel it would have the obligation to bring forward if the defense were unaware of it, that has not been identified by the defense throughout the motion practice and discovery and their exhibits and witnesses, et cetera. But I will look at the issue and issue a written opinion on the matter, because I think, obviously, at a minimum for appellate purposes, you'll want that. So with that, I don't believe we have any other motions to take up today. Did I miss any?
Your Honor, we wanted to approach the court in regard to the review of the jury questionnaire and whether that can be conducted remotely, and when the court would like to do that.
Yeah, so I haven't had a chance to look through your responses to my proposed jury questionnaire. I will do that. Keep that just as a tentative. We can do it by Zoom or WebEx or something like that remotely. There's no need to travel down here to do that. And it may be that I simply just need more time, and we'll tell you, let's take it up at the pretrial conference. I think we'll have time if we get it done at that time. So
Thank you, sir.
I didn't anticipate that I would actually get to the point where I would have given you my draft of what I think it ought to look like by this deadline. So that's part of the reason I had calendared it. So
And I can tell you, we very much appreciate that the court was able to provide us with your draft, because I think that simplified the issues, and as you review them, there are just a handful of things that are potentially in dispute.
All right. Anything else from defense?
Your Honor, with regards to the exhibits, because they're now scheduled to be due the same day, we'd actually like to see if we could have an additional week.
I will give
before-
you additional 1 week after the state's exhibits are due.
Thank you.
All right. I think with that, we are adjourned. Thank you.